because increasingly we're beginning to see, that the arbitration market is not only for lawyers anymore. Non-lawyers are also encouraged to do more, particularly because of their needs. But notwithstanding, I'm happy with the position of participants at this morning for you, afternoon for us. And so I'm going to preface my presentation with preliminary comments. And the preliminary comments have a lining of what I call the commercials of arbitration. At the end of what I expect that we take up this meeting is, where are the opportunities? How can we collaborate? Take reference from Michigan. How can the Michigan take references from Nigeria? That is the essence of this networking. And so I start by saying that arbitration, ADR, is what fastest, and we can't deny that fact, is the fastest and is the most acceptable form of disputes. When we draft agreements now, clients now mandatorily tell us to ensure that they takes them to. And so for me, it's huge untapped market, which everybody needs to take a share of. I mentioned earlier that increased participation of lawyers. How did this come? When we engage non-lawyers as experts during arbitration, they first get to see how much well they need for just to give expert evidence. Secondly, look at they see the problem is not as cumbersome what's seen in traditional. So we're encouraging a lot more lawyers, into the space of arbitration. What is even more important, there's increased evidence of growth in foreign firms and local law firms. And what leads is that we're seeing increased M&A within the legal cycle. So you're seeing foreign firms merging with local firms. All of this is towards strategically turning yourself to be attractive to potential clients who want to go into arbitration. He wants a foreign firm, a local firm. Local firm who understands the local, foreign firm who understands the laws. Better can you team together? That is from what we are seeing. And ditto increase and local cross-border trade after is now the biggest that has ever happened in Africa. And so you can imagine how much transactions are to be already going there. Naturally, the consequence of that is how much disputes will be coming up. And so I think in January of last year, I was in Ghana with the president of the Nigerian Bar Association, and we had this conversation that our lawyers also trained to be arbitrators, to be mediators, particularly for the CFTA transactions. Not many people have thought about that. That's another huge market. I've said of all these mechanisms, arbitration and mediation, I would like us to focus on those two. Conciliation is not at all, but I think where real money is arbitration and mediation. And forgive me, I keep referring to where the real money is. I'm a commercial lawyer, and I do my work and I expect to get paid. All right. So I'll be focusing on Nigeria a bit more now. And there's nothing too different. So let me start by saying that there's too different from what you're familiar with about the Nigerian laws, maybe just some slight different. So Nigerian laws, it derives its, what I will call its legal foundation, two broad perspectives. First, when you look at it from the international law, is all on the ancestral laws, and indeed its rules, and the New York Convention when it comes to enforcement, recognition, and enforcement of foreign awards. And as far as local are concerned, is derived from a 1914 Act, in 1980, whilst we're under the military regime, and we transited an act in 1999. But that federal act is a law that governs the entire country when it comes to arbitration. And as good as that, there are some loopholes in the laws. And what they've done is specific individual components have taken advantage of the loops in the Federal Act, now enact their own state laws. So, for example, my headquarters is in the commercial capital of Nigeria, which is Lagos. And Lagos State, we have the Lagos State Arbitration Law of 2009. And one significant point about this act is that whereas the Federal Act does not make provision for the appointment of an arbitrator, so we've had that argument several times, that look, the law does not make provision for a sole arbitrator, or the contract neither made provision for sole arbitrator. Where is that coming from? That has been addressed, by some of the state laws, particularly the state where I am speaking from, which is Lagos. Following suit, a number of other states have, enacted their own state arbitration laws. So states can now regulate. Regulate is not a right word, because again, we're strongly advocating against, state regulation of arbitration. It's a private proceedings, and we will always want to leave it private proceedings. Right. My focus will be who are the parties to arbitration, parties that you are all familiar with. But I thought to just draw one or two or three, sometimes we may overlook, and which we've seen here in Nigeria is gone to court, been tested. And so when those opportunities they come, we're able to deal with them. The first, infant. So usually you're told an infant in the eyes of the law cannot be. So that is not correct anymore. It is a contract that relates to the supply of accessories or a reasonable contract of service. That infant is a beneficiary. That infant can be a necessary party, in that arbitration, of course, with the guardian. Second, very important, to an arbitration is a person of unsound mind. And again, this category of people have constantly been left out, of this process. But that has also been resolved. So once there's an evidence that this fellow mentary soundness, that again, and once we show evidence that whatever or error was within that period, that sort of person can be part in an arbitration. Then I have corporations and I have guarantor sureties. But the more important one is the state. And I've emphasized it because we've had that challenge here in Nigeria, and quite often. So you've seen situations where the state government actively engages a contractor or a state party. And Elliot, when he was introducing me, I did mention, correctly so, that I also play in the oil and gas industry. The first set of 93 PSCs in Nigeria, PSCs, by the way, are professional sharing. We were my law, to a number of them. And one of the first challenges we had was that the contracts were signed by the local oil company, the NO. And when we were to appoint an arbitrator, the Attorney General nominated an arbitrator. And that became now very easily, National Oil Corporation aimed to be good and treated in that manner. But we have conflicting authorities from the Supreme Court. That's no, it is not an agency of government. It's a company on its own. And for those reasons, if that company signs production sharing contract, what it means is that you may be doing so and you could have it on behalf of the government, but for that purpose, it is a party. And so you take the assets as well as the liabilities arising from such a contract. So under no circumstance should the Federal Attorney General, who is not a party in that contract, nominating. And so we had battles back and forth over that. It was ended up in the court. But I like what Lloyd said, and I'm sure we're familiar with Lloyd. He said if a government goes into the marketplace to buy books as a commercial transaction, government should be subject to all rules of marketplace. That statement was also led to in the Nigerian case law, in the Central Bank of Nigeria. So we're seeing very clearly who or the role the state government should, when we're drafting contracts now, we're a bit clearer to whether there's one we're doing in one of the states in Nigeria where the state government will be a part in that transaction. And we said, no, for XYZ reasons, we do not think that's a good idea. So arbitration and its procedures, they are evolving in Nigeria, and we're all very excited about it. Now, do those introduce new matters, either available or unavailable? Yes, they do. Some of them were never said in Nigeria before. In fact, some of them stayed with us, and I'll come to shortly. Let me first look at matters that are arbitrable, and I think this is very important for us to so that we can guide in our clients when it comes to matters of jurisdiction, determine whether a matter that must or a matter that cannot go to arbitration. So breaches of contracts, yes. Matrimonial costs are usually not, particularly because the realm of decisions. But when it comes to the area of division or distribution of properties, usually it's a matter where the courts allow parties to sit and discuss it. And there's a third trial who superintend the process and so, anticipated. Compensation of compulsory.
Tolu, if I may interrupt just briefly, I'm wondering if there might be an issue with your microphone. I'm hearing you well, but intermittently I'm losing something, and I wonder if it might be a microphone issue. Perhaps you could either try adjusting the microphone, or if you have another microphone, give that a try. I think that's worth a try. We're losing enough that I'm concerned that not every point is coming through. Do you have a way to adjust the microphone, or?
Well, definitely not from where I am sitting from. How is this? How is audio? Is it better?
It's sometimes good, but it intermittently drops off, and I'm wondering if it's a microphone issue.
I think it's a network issue in microphone.
Okay.
And I think I'm using a better network now.
Okay.
Which in itself, it creates another opportunity for us to start looking for a better network,
Yes. Okay.
So, I am still not as audible.
Yeah, I'm losing you intermittently, but why don't you proceed? Adjust your microphone if you can, and let's just do the best we can. And thank you, and please continue. We may have lost Mr. Aderemi. Let us see. Right now, I cannot hear you at all, Tulu. Yes. Well, I think what we'll do, Tulu, since I cannot hear you at all now, I think Tulu is going to try and reconnect. Let's do this. Let's turn the baton over to Davison Kanokanga. Davison, I think that, yeah, in the interest of continuing, well, let's give the floor to you, and why don't you go ahead, and we'll wait to see if Tulu can resolve the problems on that side, because we cannot hear him at all at this moment. So Davidson, why don't you go ahead, and we'll wait to see if Tulu can make any adjustments. Davidson,
that's
welcome.
fine, Elliot. Let me try to share my screen.
Great, looks good. I see your screen.
You can see my screen?
I do. I see your browser, and now I see a PowerPoint presentation, the role of the courts.
Oh, excellent. Thank you very much for this opportunity. I greatly appreciate it. I'm just going to talk about ADR and Zimbabwe with special emphasis on arbitration. Let me start by saying that well before colonization, we already had in Zimbabwe our own traditional ways of resolving disputes. You find in Zimbabwe 4 main types of ADR, which are adjudication, arbitration, conciliation, and mediation. But out of these, the most prominent is arbitration. And our common law is primarily the Roman Dutch law, as modified by subsequent legislation. Our Arbitration Act came into effect on the 13th of September, 1996. And this is the principal national arbitration statute in Zimbabwe. Zimbabwe happens to have been the 5th country in Africa to adopt the UNCITRAL model law. Nigeria was in fact the first. And you'll be interested to know that there are about 12 countries in Africa that have adopted the UNCITRAL model law. So this means then that on the 13th of September this year, Zimbabwe will be celebrating its silver jubilee on the promulgation of the Arbitration Act. Now, through Section 2 of the Arbitration Act, Zimbabwe had modifications, the 1985 UNCITRAL model law, and included it as a schedule to the Act. Now, our Arbitration Act applies to both domestic and international arbitration. It also applies to labor and commercial arbitration. What are the arbitrable matters in Zimbabwe? These are in Section 4.1 of the Act, which provides that any dispute which the parties have agreed to submit to arbitration may be determined by arbitration. Now, in agreement, there are some matters that are not capable of determination by arbitration. These are set out in Section 4.2 of the Act. An agreement that is contrary to public policy. A dispute in terms of any law may not be determined by arbitration. A criminal matter, a matrimonial cause, unless the High Court has granted leave for it to be determined by arbitration. A matter affecting the interests of a minor or an individual under a legal disability, unless again the High Court has granted leave for it to be determined by arbitration. And then you also find in the Act as it stands that it includes matters concerning a contract as defined in the Consumer Contracts Act, unless the consumer has by separate agreement agreed thereto. The interesting thing there is that position has in fact been amended, although it is still sitting in our legislation, in our Arbitration Act. There is a new act called the Consumer Protection Act, which has repealed the Consumer Contracts Act and made consumer disputes arbitrable. So our Arbitration Act is lagging behind in that regard. We got not less than 20 acts of parliament that provide for arbitration, the resolution of disputes by arbitration. And I have set these out in my presentation. I need not go through them. We have two arbitration or arbitral institutions in Zimbabwe. The first one was in 1995, and this is the leading and most popular of the two. It's called the Commercial Arbitration Center, Harare. The second one was established in 2013 by a retired judge, Moses Hungwe Chinengo, which is called the African Institute of Mediation and Arbitration. Now, both institutions are situated in Harare, and both of them do not provide any training. They also do not have conference facilities. Now, parties are free to agree on the procedure that they want to adopt in their arbitration proceedings. Now, let's have a quick look at the role of our courts in arbitration. Act 5 of model law provides the matters governed by this model law, no court shall intervene except where so provided in this model law. So our courts generally do not interfere with arbitration matters except in a few limited circumstances. The role of our courts includes supervising and supporting arbitrations, granting leave in respect of non-arbitrable matters, Section 2 of the Act. In some cases where the parties failed to agree on the appointment of an arbitrator, and there is no mechanism for the appointment of the arbitrator in the agreement, the courts, the High Court ends up appointing the arbitrators or an institution to appoint the arbitrators. The courts also stay proceedings where there is an arbitration agreement and one of the disputants decides to take litigation route, and the other party then raises the point bound by this arbitration clause, then the court may stay proceedings. The courts also grant interim measures of protection. They register arbitral awards. They set aside awards in limited circumstances outlined in Article 34 of model law. There doesn't seem to have been any reported decision in which our High Court has refused to recognize or enforce a foreign arbitral award. International conventions, well, our Constitution provides that the state must ensure that all international conventions, treaties, and agreements to which Zimbabwe is a party are incorporated into domestic law. So customary international law is part of the law of Zimbabwe, unless it is inconsistent with the Constitution. And an international treaty which has been concluded or executed by the president or under the president's authority does not bind Zimbabwe until it has been approved by parliament, and does not form part of the law of Zimbabwe until it has been incorporated into the law through an act of parliament. When entering legislation, every court and tribunal must adopt any reasonable interpretation of the legislation that is consistent with any international convention, treaty or agreement which is binding on Zimbabwe in preference to an alternative interpretation inconsistent with that convention, treaty, or agreement. Zimbabwe is the signatory to the Convention on the Settlement of Investment Disputes between nationals of assets. It is a signatory to the Convention on the Recognition and Enforcement of Foreign Arbitral Awards, the New York Convention. Now, we got pieces of legislation that make arbitration compulsory. So where any enactment requires any matter to be determined by an arbitrator or by arbitration in Zimbabwe, in accordance with any law related to arbitration, such requirement in enactment is deemed to be an arbitration agreement in Zimbabwe. That is in terms of Section 5 of our Arbitration Act. We got an interesting scenario in the Consumer Protection Act, where Section 90 of that act provides for an aggrieved disputant to appeal to the High Court against the arbitral award. That's the only section that I'm aware of that is that sort of provision, because Article 34 of the model law lists the circumstances under which an arbitral award can be set aside. There is no appeal mechanism. This is the only section that I'm aware of. Now, arbitral awards would not be final if any of the parties has a right of appeal. So like I said, we got a very unusual situation in Section 90 of our Consumer Protection Act. Let's talk about the appointment of arbitrators in Zimbabwe. As we would all know, apart from the rendering of the actual award, the appointment of a tribunal is the most important decision in any arbitration. Article 11 of the model law provides for the appointment of arbitrators. No is precluded from acting arbitrator by reason of their nationality. Parties are free to agree on the procedure of appointing an arbitral tribunal. Now, where under an appointment procedure agreed by the parties, a party fails to act as required under such procedure, or the parties are unable to reach an agreement expected of them under such procedure, or the party, including an institution, fails to perform any function entrusted to it under such procedure, then any party may request the High Court to take the necessary measure unless the agreement on the appointment procedure provides other means of securing the appointment. This is where the High Court may end up appointing an institution which can then appoint an arbitrator. So our High Court has in the past ordered the Commercial Arbitration Center to appoint an arbitrator and set up those cases there. You may be interested to know that there are no qualifications at the moment for the appointment of an arbitrator that are set out in the model law. So if one wants to be an arbitrator in Zimbabwe, all they do is write a letter to the Commercial Arbitration Center and say, look, this is who I am, this is my CV, I would want to be included on your panel of arbitrators. If the Commercial Arbitration Center is happy with that application, then they're included on the panel of arbitrators. To be senior lawyers and retired judges. Those who have received training, who have received it outside the country, since there is no team of arbitrators that is happening in Zimbabwe at the moment. You also, the only book, local book available in Zimbabwe on arbitration is a book that I published last year. with Juta in South Africa entitled Commercial Arbitration in Zimbabwe. That's the only local literature that you will find on arbitration in Zimbabwe. Now, when it comes to the appointment of labor arbitrators, Section 98 of the Labor Act then provides that one must have, it then these qualifications. One must have experience and qualification in arbitration. These do not apply to commercial arbitration. Now, again, with our labor arbitration, which is enshrined in the labor arbitration,
Davidson, we appear to have lost your audio and maybe your video as well. So I think, yeah, Davidson, Davidson, you're muted at this moment. Let's do this.
Yeah,
Davidson, great, good. So you're coming through fairly well. If you can finish up your prepared comments in about 5 minutes, I would like to turn the baton back over to Tolu to finish his prepared comments, and then I would like to leave some time to address questions from the audience, of which there are several. So if you can finish your comments in 5 minutes or so, that'd be great. Please continue.
Oh, sure. Let me try and do that. When it comes to the appointment of counsel in arbitration matters, our law does provide that anyone can be, you can be appointed. Everybody has a legal right to be legally represented. It's a constitutional right. But if you are a foreign lawyer, then you obtain authority from the Minister of Justice by way of an exemption certificate that is issued by the minister. And in order for the minister to issue that certificate, he must be satisfied from a country which is designated as a reciprocating country. Now, a reciprocating country is one whose law admits to the practice of law in that country, whether generally or been thrown off the line again. Can you hear me?
I can right now. Yes, I can. Yes.
Can you hear me?
Yes. Please continue.
Okay. So the minister must be this is an important matter. It's complex. There are special circumstances that justify the hiring of a foreign lawyer, and that the counsel is not normally resident in Zimbabwe. So when one is issued with that exemption certificate, they can only practice in respect of that particular matter to which the certificate relates, and that certificate will automatically lapse in respect of which it has been granted. For the sake of time, let me stop here so that I hand back time to you, Elliot.
Well, thank you so much. And I will hand it right over to Tolu.
Thank you, Elliot. And I was just hoping that Davison will carry on, because I was enjoying myself here. I've already started talking with some people. People have been sending me private messages, and and I think this is the essence of the entire exercise. All right. We're going to save a lot of time because quite a few things I was going to touch on, I think Davison had touched on them, so I would not repeat them, unless, of course, there's a variation between the Zimbabwean market and the Nigerian market. And so before my network took off, like I told Elliot, I was on what I've called the non-arbitral matters, arbitral and non-arbitral matters. And I think this point is extremely important because a number of times when clients pushes us to go and issue notices of arbitration, we don't look at the subject matters. So I had listed out what were the arbitral matters. Let me move now to the non-arbitral matters. But before I do so, one last point in the arbitral matters, matters which you can arbitrate upon, is landlord and tenancy matters. Now, there's no law that says you cannot, by arbitration, resolve a landlord and tenancy matter. But I personally think it's a worthless exercise. When you look at a landlord and a tenant, there's only one possible or two possible types of dispute. Either the landlord wants the tenant out of the premises, or the tenant does not want to leave the premises. I don't need to go to arbitration to resolve that because the tribunal does not possess the coercive powers to get that tenant out of the property. So really and truly, I've always advocated that we should do those sort of things by the court. And I say this because there are a number of matters that can only be resolved by court. And so I move on to non-arbitral matters. Like Davison said, criminal matters are non-arbitrable, except for plea bargaining. So when you get to the stage of where within a criminal matter, plea bargaining, can be resolved by a third party and neutral. Election petitions are not arbitrable matters. Same thing for divorce petitions. They have to go through a regular courts. Tax disputes. Now, this is very important. And I say so because what you will find in practice is that whether by law or by contract, a number of provisions or a number of contractual and commercial terms are now interwoven with tax considerations. So take, for example, the Deep Offshore and Inland Basin Production Sharing Contract Act in Nigeria. Its Section 4 provides for the allowance of investment tax credits. Now, that is huge dollar for dollar payment into the pocket of the contractor. And this is the only place where that tax provision is made. And so therefore, it becomes very easy for you to think that question of tax is by law, but you also find it in the PSCs. In fact, in the PSCs, the methodology by which the taxes are distributed, by which the taxes are paid, by which tax receipts are issued, are all in the production sharing contract. So it's easy for you to fall into that error that the contract also makes provision, for tax liabilities. So in one of the arbitrations we handled, which was in the oil and gas, the claimant thought or put up a very commendable, strong argument that those tax matters were matters within the jurisdiction of the tribunal. When you look at them very carefully, you must do what we call a surgical analysis of, a case by case or a clause by clause of the PSC, and you will see that they all have consequential effects on the tax. The tax is a revenue of government, and therefore different tribunals can come to different conclusions in respect of the same revenue of government. I know government wants to do that. Anyway, so that's why tax disputes or tax matters, are non-arbitrable matters. We were in court for several years, all the way to the Supreme Court, and I must say it was an exercise that we did enjoy. All right, let me move on very quickly to party representation. I will not skip this because I think it's very important. Davison had talked about who qualifies to be an arbitrator. And I look at them from two angles, whether as an arbitrator or as counsel. And so everybody on this platform this afternoon, you're looking at either of those two options. Can I become an arbitrator in the state of Michigan? Can I become an arbitrator in Nigeria? You need to know whether you can sit in the role of an arbitrator, and if you have a legal background or you have a legal qualification, whether you can sit as counsel. Those presents two opportunities. So for an arbitrator, the contract can nominate you by agreement of parties. But we've also seen situations or instances where the parties have inserted into the contract a provision for an institutional appointment in the unlikely event that the parties are unable to agree, on appointment. So you have entities like the LC, the Lagos Court of Arbitration, the Regional Center for International Commercial Arbitration, can appoint you as an arbitrator. Even where the parties did not make provision for that in their contract, they can, by submission agreement, also appoint you. And in some cases, the statute can appoint you. But how can you be a counsel in arbitration? I can sit in Nigeria, I can be from Nigeria, or my office can be in Nigeria, and I've had arbitrations around the world, in Australia, everywhere, and I'm not from those jurisdictions. So what are the nuances, the legal nuances that we must know? In Nigeria, yes, the contract can also. So what is built around all of this is what I call the party autonomy, which is why arbitration is attractive to many people. But hey, there's a small challenge. And what is that challenge? That challenge is, by the Arbitration Act, that a representative or a counsel of a party in an arbitration must be a legal practitioner. That's in Article 4 of the Arbitration Act, first schedule. And so we had an arbitration before where an objection was raised that a foreigner, there was a counsel on the other side from London, and the argument was successful because we went to look at the definition of who a legal practitioner is. It says a legal practitioner of choice. And so you now have to go back to the Legal Practitioners Act to go and look at the definition of who a legal practitioner is. And it says it must be a man or woman called to the Nigerian bar. So that was a major setback for us in the arbitration community. This was a time when we're looking forward to making Nigeria an arbitration hub. That provision was going to militate against it. So the way we've gone around, and in the UK, they went around it. So if you go and look at the UK Arbitration Act, what it says is a legal representation or representative of choice. And so you could appoint anybody, not necessarily. So I could be appointed counsel in an arbitration under English laws. I will only decline because I'm not trained to interpret English laws. So that was a setback for us. But the way we've not gone around it, and as a matter of practice, and this is what we do constantly, once there's a challenge, we all sit together, we think about it, and we need to work around it one way or the other. So we still collaborate with foreign lawyers because we have to anyway. When you talk of certain skills, those skills are not here. And so you must collaborate with some of our foreign partners. So when we go to hearings, the first thing we do is that you seek the tribunal's permission to let them know, look, I have my colleagues from XYZ law firm, from XYZ countries, they are consultants, and I trust the other party is happy with it. So it's an application that you make. And usually because it's the same community, we all know what the challenge is. We get the other party to either agree or raise objections. Most times objections are not raised, and then the tribunal will allow it. So that's how we've been able to get around that. I have here rights and obligation of the parties. Gentlemen, I will skip a number of this because of my time and because of your time. But let me quickly touch on the powers of the tribunal. I think David taught, and I'll run through them very quickly. So there are general powers, those contained in the Act. General powers, those contained in the laws governing the arbitration procedure, which is the lex arbitra, and then the laws governing the agreement itself. But there are some specific powers which I think cut across board, but I think, I must mention it because we have it here in Nigeria. It's competence. No matter what the objection is on jurisdiction, the tribunal has the powers to determine whether or not it has powers to sit over that sort of matter. That's what we call, and you find it, of course, in the constitutional. The tribunal also have the powers to determine the place of arbitration. I remember a hearing we had some time ago. Parties agreed that the place would be Lagos. But unfortunately, there were bombings here and there in Lagos. And we took a strong view that, look, the parties had agreed. What the law says is where parties do not agree, then the tribunal, by their terms of reference, can take a view on the place of arbitration. But the day after we made that submission, very strong submission, we're very excited about it. There was a bomb that went off in Abuja, October 1. I can't forget that date. And then the Kaplan, of course, I can mention his name here because he just wrote to parties, gentlemen, I hope you still maintain your view that Nigeria is the safest place to hold. Of course, we couldn't see anything. And the man took us to Australia. So the tribunal can decide, the place of arbitration. Same thing for language. Matters of disclosure, extension of time, appointment of experts, they are matters that the law and indeed the contract donates to parties. I move quickly to the powers of court. Davidson had talked about a number of those things, so I will not repeat all of what he has said. But
if I may briefly interrupt, so we're approaching the end of our allotted time. I want to make sure that folks who have a hard deadline at 11:30 have a chance to ask a question. So I want to interrupt your presentation, but I also want to say that I'm willing to stay on after 11:30 for so long as anyone else is willing to stay on and continue the discussion. So we can pick up again with your prepared comments or with others from Davison or with other questions. But before we get to the past the hour, I want to invite the audience to contribute any comments or questions. Is there anyone who would like to? And if so, feel free to unmute yourself and pipe right up.
Well, Elliot, if you give me 1 second, just before that, and I know some people need to jump off, I will run quickly to slide 15 of my presentation. I'll come back to the rest if there's time. But slide 15 talks about the opportunities. I think if you take nothing away, I think that's an important point you need to take away. And I do say that there are few specialist arbitrators and counsel in Nigeria. This is an area of opportunity for us to work together. There are few specialized ADR centers also in Nigeria. Incidentally, one of us here and I were about starting one now. And so this is an opportunity to also collaborate. What I've called best friend relationships between Nigerian law firms and foreign law firms creates this sort of opportunities, gentlemen. I think the best time for us to work together is now. And let's exchange values and we exchange dollars. Thank you very much.
No, thank you very much. And by the way, your sound is perfect now, Tulu. Thank you for the adjustments you made on that side. Is there a member of the audience who would like to comment or question? Anyone? Feel free to unmute yourself and jump into the conversation. If not, I want to raise a couple issues that have been commented on in the chat, and I'll thank Ayodiji Olunlade for the comment regarding arbitration in family matters, and I'll thank Tulu for his response on that. Tulu, do you want to summarize your response on arbitration as it applies to family matters?
Yes, thank you very much. So I did say to Mr. Olunlade that naturally when it comes to matters, particularly when children are involved, where children are not involved, but you are discussing distribution of properties, it is sometimes subject to a private hearing where you have a third party neutral who, I would call that a hybrid case. And we have MedArb, which is a hybrid of mediation and arbitration. So that is what happens there. But when children are involved, it is almost sacrosanct that parties will have to resort into a private hearing and a third party neutral will sit. And there are many things that are considered during that process. So it's a matter of practice and procedure.
Thank you, Tulu. And Davison, I'd like to give you a moment to comment on this matter as well. So family matters and arbitration of family matters, and specifically parenting arrangements and support. How is that addressed under Zimbabwe law? Davidson, you're on mute, but I would like you to comment on that if you care to. Do you want to comment? You're still muted. There you are. Okay.
Sorry, can you repeat the question again?
I can hear you now. Yeah. The question originated from Ayodiji Olunlade, and it's about the scope of arbitration in family matters and should it be extended to parenting arrangements and support. So how is arbitration? How does it deal with family matters under Zimbabwe law? And is there anything you would like to say in response to that question?
Yes, family matters are not arbitrable in Zimbabwe without the leave of the High Court.
Mm-hmm, mm-hmm.
This is one area where there is actually information which we also are not using much of at the moment, save in very few instances like labor matters. Our new Companies Act does provide for mediation, but there is a lot of scope for mediation in family matters. Unfortunately, mediation hasn't really taken off in Zimbabwe. So we still have a long way to go in that regard.
Thank you for those comments, Davidson. And so another question that occurs to me as I hear about the arbitration systems in both Nigeria and Zimbabwe, one thing that I like about those systems is flexibility. It sounds like there is a desire to be inclusive, to permit people to apply to be arbiters without fixed qualifications, but to let it be discretionary of the overseeing board, and I like that idea. Tell me about the other part of that. The other side of that question, I think, is consistency. So flexibility, consistency, flexibility, good, consistency, good, and I see there being perhaps a trade-off there. How does that play out in effect in those two jurisdictions? And Tulu, maybe I'll go with you first. Does flexibility affect consistency or not? That's just hypothetical.
The simple answer to that is flexibility and consistency. They do go together. Reason being that the nature of disputes that go to arbitration in Nigeria are largely commercial and very sensitive disputes in nature. And so what it means is that from time to time, you always need to have expert partners or expert opinions in respect of some of these disputes. And so the structure we have here is I am allowed to work with anybody as counsel. However, if as arbitrator, because of what I've also described as the party autonomous nature of our structure here, I'm also allowed to nominate anybody who I feel can sit as an arbitrator. Now, as counsel, I had mentioned the challenge we have, with the definition of who a legal practitioner is. But even at that, we have successfully been able to work around it as a matter of practice and procedure, seeking the other side's consent and getting a tribunal to rule over that application. So I think for us, we have no choice at all about this. The nature of matters are so complex and so technical, that even before you submit your pleadings, you need an expert opinion on it. And so clearly, from time to time, we find ourselves in positions where we need to collaborate with experts, foreign experts for that matter. And but in addition to that, the institutions in Nigeria have also set some parameters. So, and this is a matter of getting more work, quote unquote. So you can either be part of the Chartered Institute of Arbitrators, for example, Now, before you are a member of that institute, you must write their exam. And so we have lawyers, we have judges, we have non-lawyers who are also members of the Chartered Institute. So to train you, most of what we have discussed today are products of the training of the Chartered Institute, which I belong to, by the way. But again, you don't have to be a member of the Chartered Institute of Arbitrators for you to be appointed an arbitrator in Nigeria. So the flexibility, I see, we've done very well in Nigeria regarding flexibility and consistency.
Well, that's fascinating. So if I hear what you're saying, because of the range of issues that one must address, you actually need to have a flexible standard so that you can appoint experts in the subject matter to
more like the complexities. I mean, so I tell you, for example, when we had dealt with the PSCs in Nigeria, the 93 PSCs, there were clear tax disputes. At that point in time, we had not had any tax oil-related disputes, none at all. And so we had to go to, I think we went to Zimbabwe, I think it was Zimbabwe, one of the countries where there was the closest, and you know, that sort of law is a persuasive authority in Nigeria. The Nigerian courts are not bound by it. So I'm happy to say ours was the first, you know, to form an authority or a precedent that other courts are now following. But we had to collaborate, engage the services of foreign partners to look at this because it's happened in other jurisdictions. And so we needed to borrow from there to be able to, you know, make a robust pleadings before the tribunal. So we had no choice about it.
Understood. And thank you for the clarification, Tolu. Davison, I'd like to give you a chance to respond to this question about flexibility versus consistency. And then I would like to give each of you a minute or so to make any closing comments. And we're going a little over here, but I think that's appropriate given the fact that we've had some technical hurdles. And I want to make sure that everyone has the chance to be heard. But before I continue with Davison and then go back to each of you for closing comments before we formally adjourn, I would like to again ask the audience if there's anyone who would like to comment verbally or or introduce a question to the conversation. If so, please unmute yourself and pipe up now. Anyone? Anyone? Going once? Going twice? Okay. Then let's go to Davison for a response. Let's go to both gentlemen for closing comments, and then we'll formally adjourn. And I will hang on the line, and anyone else who wants to continue the discussion is welcome to after that. Davison, please.
Thank you. Talking about flexibility, you find that professional bodies that can appoint arbitrators. For instance, you got the Law Society of Zimbabwe. What they do is simply send out a letter to lawyers to say, if you would want to be included on our list of arbitrators, please let us have your name. That's all. So you send them your name and you're on the list of arbitrators. Whether you have any training or not does not seem to be a consideration. Now, when it comes to consistency, you find that when it comes to procedural matters, yes, you tend to have consistency. When it comes to substantive matters, that's a different issue altogether. You may have inconsistencies there. But now, when an aggrieved disputant takes the matter to the High Court and they want the arbitral award set aside, there's a strategy there. Your application must fall within the parameters of Article 34 of the model law. And the courts are very, very reluctant to interfere with the arbitral awards unless the award violates Zimbabwe's public policy. And Zimbabwe is the leading authority on policy. You find also that there is consistency when it comes to the judgments that are handed down by the High Court and the Supreme Court in respect of arbitration matters. You may want to know that, in fact, our courts have interpreted almost 3/4 of the articles in the model law. So it is, Zimbabwe is one of the leading African countries when it comes to interpreting articles in the model law. So there is consistency in that regard when it comes to the judgments by the High Court and the Supreme Court.
Well, thank you for that interesting response. And I like your differentiation between procedural consistency and substantive consistency, and what's important and when. So thank you. And gentlemen, if you would both like to close, at least formally close here in 60 seconds or so. Tolu, any messages for the audience in closing?
Thank you, Elliot. I think it's been a good exercise. 2 points I will just leave gentlemen and ladies with, and I think we can engage subsequently after this event. The first point is that Nigeria is a developed arbitration market, and the courts are becoming more and more reluctant, to interfere in arbitral processes. They can intervene, but they only also intervene in matters or in areas that are not covered by the Arbitration Act, such as where you have a tax dispute. So I like to reiterate that confidence in everyone, that Nigeria is a market where arbitration is thriving, arbitration is growing, and the courts respect arbitral awards. The second point is also, I think we should form formidable clusters of relationships, more importantly, on a sector-focused area. I think for me, how we can exchange transactions or we can exchange opportunities are on a sector-by-sector basis. Nobody will collaborate with a general practitioner. So in oil and gas, I want to collaborate with you because I know you have some expertise that will be useful to me, in my practice. You want to collaborate with me because I have that expertise that is also going to be useful to you. So I think with that mindset, we should come together, and I think we can. And finally, my good friend here, Aaron, and I are floating an ADR center, which it will come live very soon. It's also an opportunity for a number of you, and it's Nigerian based. So it's an opportunity for a number of you to also get enlisted either as arbitrators, and you can ask for more information about it. And once we finally and formally set up, we will share those information with you. It's also a good entry point into the Nigerian market. Thank you, gentlemen.
Thank you, Tolu. And Davison, closing comments?
Elliot, a big thank you to you for this wonderful opportunity. A big thank you to Aaron as well. It has been my pleasure having this conversation. It's my prayer that this is the beginning of a long-term and fruitful relationship. So I look forward to more interaction with yourselves. Once again, thank you. I appreciate it.
And thank you. And thank you to both of you. So COVID-19 has really presented this silver lining, which is this opportunity to connect with folks around the world, which I just hazard a guess would not have happened last year. But this year we're privileged to have speakers such as Mr. Aderemi, Mr. Kanokanga, and to hear something about the practice of law in places that are very far from West Michigan. So it's a real privilege for me personally, and I'm speaking on behalf of the section, to hear something about how disputes are resolved elsewhere in the world. I would like to ask you if you would mind sharing your slides, and you can simply, if you don't mind sharing your slides, please send them to me. by email, and I'll distribute them to the section with your permission. So whatever you want distributed to the section, please feel free to send it to me. With that, I will thank both of you, and also perhaps provide your contact information, and I'll send that to the section as well. That way, if anyone wants to reach out in response to this, they'll have the ability to do so. Any final words from the audience? From Aaron, personally? Aaron, is there anything you would like to say?
I just wanted to thank the speakers and you for putting together an excellent program.
Well, I'm going to redirect the thanks to you for actually pulling it together. So I'm merely a figurehead here. And so thanks for your work, Aaron, and reaching out to Tolu and Davison and making this happen. So thanks to all. I'll hang on the line here if there's any questions or further discussion. But it's been a real pleasure to interact with all of you. Thank you, and take care.
So thank you, Elliot. I think that was a good. I think it was a good session. The time was short, though.
Yes, it always is.
There's no way you can do justice to this sort of topic in 1 hour. Maybe what we may consider doing, or what you may consider doing, and I was thinking of doing it before, was to share my slides ahead of time, right? So that whilst you're paraphrasing, your audience, you already have the benefit of, the fullness of your slide presentation.
That's a good idea.
Yes, so
I like that.
But I think it's what is arbitration like in Michigan? How developed is it? Is it also sector focused? Is it what is it like?
As a person who is not an arbitrator, I can't speak to that. But is there anyone on the line who could respond to Tolu's question? Yeah, so I'm not a member of the ADR section, and I don't do much dispute resolution. So my practice focuses mainly on civil law, contractual law. It's mainly prospective, not retrospective, in the sense that I'm usually engaged in forming a relationship, mostly contracts for technology, mostly commercial contracts, licenses, service agreements that involve technology, and usually software. Usually it's software.
And so what happens when you have disputes arising from those contracts? Because I essentially, so my first 4 or 5 years of practice, I was a core litigator. I was going to the court every day. But later I switched to being a solicitor. And so I was doing a lot of contracting, negotiations, etc. But what I've also found out is in the course of my work, disputes would or do spring up. And when they spring up, rather than send it to another department within my firm, there are matters that I can take up myself because I also understand it better. When you draft a contract, you're obviously going to be far more knowledgeable than someone who's just reading a contract to be able to draft pleadings. So now I find myself, I still go to court, but not as often as I really would love to. So probably in a quarter, maybe once, even if I'm lucky. But what takes me to court are matters arising from commercial transactions that I'm a solicitor in. So that's how I've found myself, back in court. And even indeed arbitration, of course, arbitration, they all come from any angle. But even litigation, I still do some arising from commercial disputes.
Mm-hmm. Well, one thing I can let you know is that Davison commented on mediation. Court-ordered mediation is common in Michigan. It's widely used by judges in Michigan for all kinds of disputes, but commercial disputes in particular. So to be ordered to mediation in advance of litigation, and often mediation will resolve it. So mediation will result in settlement in the vast majority of commercial cases here. And those mediators are, there's usually a panel. There's a panel of 3. They're appointed. I'm not sure what the appointment system is, but I think they do have to have some, there's some experience requirements. They have to practice for more than a certain number of years, and I think have experience in the subject matter as well, as Davidson alluded to.
And so yeah. mediation awards, are they entered as judgments of the court such as it becomes binding on the parties?
That is a good question.
Because in Nigeria, that's what happens.
Well, I think this is true. I think that whatever the mediator comes, I think the parties write up a settlement that is then certified by the court. I think the court certifies the parties' agreement, whatever that is. I do think one interesting feature of mediation is that the mediators will recommend an award. They'll say, okay, we think this amount of money is compensatory. And there is some penalty for not accepting that. If you don't accept the mediator's agreement and you go to court, and I would have to review those rules, but there is some disincentive to rejecting the mediation panel's opinion.
Well, usually my experience also as a mediator is most often than not, a mediation report or award is consensual in nature. And so it's almost unlikely, that you will have a mediation report and one of the parties will renege. Because what the mediator or the mediators would have done was to evaluate the strengths and weaknesses of the respective cases and come up with an agreement or an agreed position. But what we've also done in Lagos is that, so we've amended the rules in such a manner that if there's no consensus, then the parties are sent back to the court and then they go through full-blown trial. But if there's an agreement, yes, if there's an agreement and you're successful in having a mediation report, that document is now entered into the court as a judgment of the court. Now, the trick there is once it's entered as a judgment, it's almost like your settlement agreement. Once it's pronounced upon, neither of you can back out of it. If one party does not comply with it, then the other party can file a Form 48 and 49, which is committal to prison, because that's disobedience of a court order. So that was, what I found to be ingenious, that was introduced, into our mediation practice, that now more or less compels. So what you find, sometimes people won't just bother with mediation. That look, you know what, let me just stay with arbitration. I'd rather do arbitration than go for mediation, because sometimes the mediation is almost as if you're back. The consequence of it is as if you're back in court. But there are different conspiracy theories about the potency or otherwise of mediation. Well, Elliot, let me thank you very much. I need to run. I'm going to share my slide. I'm going to share my slides with you. The last page of my presentation, it contains all my details. So the emails and the contact telephone numbers. And then please, if anybody who has any question, which we were unable to address here, I think let them feel free to share those questions. I will treat all of them.
May I share your email address then, which is probably in those slides?
Oh yes, my email address, my contact telephone number, everything is there.
All right, will do. It's been a pleasure. Excellent. Very nice to meet you.
Same here, and I'm hoping that we will get to do a lot more together. I might drag you into speaking at one of my platforms. I'm also the training committee chairman of the Nigerian Bar Association. So really? I do trainings for all the lawyers annually.
Well,
You know,
that's
so-
a big responsibility.
Well, it's
I
tough for
sympathize.
me on work.
Yes,
You
no
know,
doubt.
but we'll so what I can do, so there's a technical part of it and there's a soft skill part of the trading. So maybe later today I could share my calendar with you, look at it and see whether there's any area you think you have expertise in, or you can recommend someone who can speak on it for me.
Okay, happy to do so. Thank you, Tolu.
Excellent. Is Aaron still here or is gone? I think Aaron is gone.
Yep, I think Aaron took
All right.
off.
Thank you, Elliot. I'll chat with you later.
Take care, everyone. And I'll close the meeting now as well.